Hi, this is Cora Stack again. I have another important video to make, and I'll explain what it's about. And it's like time is running out, and you're writing a lot of papers at the moment, and it's because my life was such that I wasn't in a position to I had it all accumulating in my mind, but a lot of this is just coming out now in the last few years. So it's feeling like I have to keep writing and writing. So anyway, the silent inequity, gendered outcomes in marriage breakdown. Marriage breakdown, separation, and divorce are often framed as private events, but statistically, they're structural events. And across jurisdictions, the outcomes are not evenly distributed between men and women. Today, early in the morning, I want to examine the long term inequities facing midlife women, inequities that are measurable, predictable, and frequently under recognised in family law processes. My name is Dr. Cora M. Stack. My research and policy work has recently reached the top 1 percentile globally for views on academia.edu. And this paper, surprisingly, perhaps not so much surprisingly, but the silent inequity is emerging as one of the most widely engaged with the read. Courts are indispensable. So I'll give a brief summary of this paper, very, very brief, because it's much more comprehensive. It's much longer than this. So courts are indispensable institutions, but legal architecture must evolve in response to evidence. Statistical reality. Empirically, men tend to recover economically more quickly than women following marriage breakdown. On average, men's income trajectory is stable faster. Men are more likely to repartner. Men's housing security therefore improves more rapidly. Men's pension accumulation remains stronger. And women, particularly in mid-life, face significant cumulative disadvantage in comparison. This is visible across Europe and internationally, according to my research. Midlife women face limited time to rebuild careers, suppressed lifetime earnings due to caregiving and putting their career second to their husbands, former husbands, pension deficits that cannot be fully recovered, and reduced borrowing capacity and greater housing instability in particular. When future economic modelling, so this is where I feel the issue, there isn't any future economic modelling applied in the in the determinations in these kind of cases. It's just split the current assets in inverted commas in two, and that that in itself has implied can have very implied discrimination embedded into it. So when future economic modelling is applied, housing costs, retirement risk, healthcare expenditure, the asymmetry becomes clear or more evident. Yet legal settlements frequently focus on just present division, and it just divides by two, irrespective of what happens. What happened in the past or what is going to happen in the future, on present division rather than future or past vulnerability. There's also a cultural dimension. In many societies, it's completely socially acceptable for older men to repartner with younger. Remember, this is almost expected, that a man will abandon his wife and, partner with a younger woman, and it's seen as cool that he's achieved such success, inverted commas, and instead of seeing it for what it is, total betrayal, total and absolute betrayal. So the reverse is not culturally symmetrical. Older women face greater stigma and reduced social opportunity in repartnering. Repartnering affects economic recovery, housing access, and social capital. This asymmetry compounds financial inequality. And another whole issue of discrimination. There's the discrimination against single women is significantly greater than the discrimination against single men by and large. Long-term health and psychological risk, prolonged financial stress, and this kind of hidden discrimination of women who find themselves in the situation who are often marginalized and isolated by their previous social set, and relational trauma are associated with chronic anxiety, mental health conditions, immune system dysregulation, cardiovascular risk, accelerated aging. Midlife women experience, this is what the research indicated, economic instability, face decades of compounded vulnerability. These are not just short-term adjustments, they are life course consequences. And so what I'm saying here is that what this division of acts is completely wrong when you look at the actual evidence in terms of if you were to do a long-term longitudinal analysis of the actual facts, and if you just look at the historical the facts about what has happened to women post midlife in the past 20 and 30 years. I mean, this is not taken into account in terms of the settlements made to women in these kind of cases. Absolutely not. And women are structurally hugely disadvantaged by the current systems. Parental alienation and relational harm, where coercive behavior, dominating behavior exists, or coercive abuse exists, or narcissistic abuse, or that sort of abuse, very difficult to explain that. That's very rarely, narcissistic abuse is something that almost cannot be mentioned in a court. And when you ask why can't it be mentioned in a court, nobody really has an answer. But it is much more serious. It's patterns of that are not kind of incident based, and therefore are more they seem to be, as I've written in another paper, they're out of the scope of the adjudication process, really out of the scope, because they're not incident based, but they are extremely harmful. Where coercive behavior exists, children may become instruments of post-separation domination. Parental alienation creates long-term psychological injury for both children and parents, in particular mothers, yet adversarial systems still remain not well equipped to identify or interrupt relational manipulation early. Trauma responses can be misinterpreted as instability. Children's expressed preferences may be accepting without examining underlying coercion. Again, this reflects structural limitations, not individual blame. So this is what I'm proposing as the missing structural layer. So this is what I'm proposing as a remedy. But perhaps the most significant gap lies earlier. Marriage deteriorates over time. I mean, that's almost inevitable in today's complex world, stressful world. Conflict accumulates. Resentment deepens, yet there is rarely a mandatory, structured, multidisciplinary forum to examine whether a relational repair is possible, state-funded, whether coercive patterns can be addressed, whether financial restructuring could relieve pressure, whether therapeutic intervention could stabilise the family. Instead, the first institutional entry point is often adversarial. Court. Adjudication. I've been trying to understand adjudication for a long time. I think I got my head around it. Adjudication is first response. Adjudication is designed to divide. It must determine competing claims, and it's based on who makes the best competing claim, not who is most harmed in the process, or who's harmed before going into the dispute. It is a dispute resolution system, but it uses adjudication to determine, winners or losers, certainly in this kind of case. But it must determine competing claims, which depends on your ability to adjudicate, which depends a lot. It cannot function as a healing space as a result. When court becomes the first structured response, narratives polarize, positions harden, conflict escalates, children become part of litigation strategy, division becomes institutionalized. So in earlier work, I proposed trauma-informed arbitration. Since then, having understood arbitration as primarily adjudicative, my thinking has evolved. Arbitration remains essentially adjudicative in the manner described above. It still centers imposed decision making. It does not fundamentally shift the architecture, so the diagnosis remains the same. The inequities remain measurable. What differs now is the remedy. So what I'm now advocating in more recent work is for a mandatory trauma-informed, state-funded, problem-solving centred, multidisciplinary process before court engagement, except in urgent safety cases. Courts remain essential for protection, for enforcement, for safeguarding, for precedent, but in my opinion, given the research that I've done, and the engagement with the papers that are, looking at this and examining this as a possible remedy for this almost institutionalized discrimination, long-term discrimination against women, which we're not going to blame anyone. We're just going to say it probably hasn't been properly explored in terms of when laws are introduced and the impact of those laws over time on those that are impacted by those laws. So, but they should not be the first response to relational fracture. This is why this matters. If we integrate long-term economic modelling, caregiving valuation, trauma literacy, and child development expertise before adversarial escalation, we may reduce intergenerational trauma, reduce pension poverty, reduce housing instability, reduce litigation hostility, reduce likelihood of psychological, mental health disorders or effects, and improve social cohesion. That's very important, I think. There was a group of very senior judges a number of years ago came out in the UK and said, that divorce was the scourge of modern society, as they understood it, and that has disappeared now. But that was a campaign for quite a while. So this does not guarantee relationship survival, but it guarantees structured examination before irreversible division. Closing. Statistically, men tend to recover more quickly than women after marriage breakdown. Particularly, midlife women often carry cumulative disadvantage across decades, and this is now measured and measurable. These outcomes are predictable. Where future vulnerability is not adequately modelled or compensated, inequity becomes embedded in neutral processes. Courts are crucial, but healing must precede or should precede adjudication. If we want more cohesive families and societies and more equitable outcomes, I feel we must redesign the entry point. Thank you for engaging in this work. So this is it's stunning for me that this is one of the most widely read papers, and that this has sort of catapulted me, along with all my other work on access to justice in particular, family law, constitutional law, and protective disclosure whistleblowing, into the top 1% category globally of views of work on academia and platform academia.edu.